Chapter 8, Property Rights. In Chapter 8, you'll be presented with the physical components of real estate, rights, estates, tenancy and ownership interest, as well as special ownership interest, including the constitutional homestead. The chapter also includes a thorough explanation of cooperatives, condominiums, and timeshares. In the end, you'll be able to define real property based on the definition in Chapter 475 and explain the physical components of real property. You'll be able to distinguish between real and personal property and explain the 4 tests courts use to determine if an item is a fixture. You'll be able to describe the bundle of legal rights associated with real property ownership. You'll be able to list the principal types of estates and tenancies, describe their characteristics, benefits, and protections associated with the Florida Homestead Law. You'll be able to distinguish among cooperatives, condominiums, and timeshares and describe the main documents associated with condominiums. Here's your list of vocabulary for Chapter 8. Definition of real property. This is by 475 Florida statute. Real property or real estate means any interest or estate in land and any interest in business enterprises or business opportunities. It does include mineral rights, but it does not include cemetery lots nor the renting of mobile home lots or recreational vehicle lots in a mobile home park or travel park. The physical components. You have surface rights, subsurface rights, and air rights. The surface rights include land and water rights, and there's 2 types of water rights. You have riparian and littoral. Your subsurface rights are also referred to as mineral rights, and then the air rights involve the space above. Riparian versus littoral rights. Riparian rights are associated with land abutting moving water, banks of a river or stream. Littoral rights are associated with land abutting tidal bodies of water, such as oceans and seas, ponds and lakes, and the water's not flowing. So riparian, you remember, it's river rushing. So I think of RRR, riparian, river rushing. The water's moving, okay? Littoral, I remember that with LLL. Littoral, lazy, lake. The water's not flowing, it's just kind of sitting there. Now, some people get confused with oceans because they're thinking of the currents and the waves and that it moves. That's true, it does, but it's really a big body of water that just kind of sits there. It doesn't flow in one direction. Definitions associated with water rights. You have accretion and alluvion. Accretion is the process of land buildup from waterborne rock, sand, and soil. Alluvion is what happens. That's the new deposits resulting from accretion. Erosion and reliction. Erosion is a loss of land due to natural forces, and reliction is the receding of water, uncovering additional land. Real property versus personal property. There's 2 basic types of property. You have real property and personal property. The word realty, that's where we get it from, real property. Personal property, you get that from personalty, or most times it's referred to as chattel. So you'll need to know that chattel means personal property. Real property becomes personal property by act of severance. It's separated. So it was once real property, but now it's personal property. And personal property can become real property by attachment. It once was personal, but now it's attached to the real property, so therefore it's a fixture and becomes part of the real property. The way the courts determine whether an item is part of the real property is by the test IRMA. A fixture was personal property now permanently attached to or made part of the real property. IRMA, I, the intent of the parties. R, relationship or agreement of the parties. M, method or degree of attachment. And A, the adaptation of the item. Your basic property rights are remembered with the acronym DEEP C. Disposition, enjoyment, exclusion, possession, and control. Estates and tenancies. You have freehold and non-freehold. The degree, quantity, nature, and extent of the interest, the ownership rights. There are two general groups. You have freehold and not freehold. Freehold is where you own. Non-freehold is where you're leasing. You're not free to own. Freehold is for an indefinite length and unknown duration. Where non-freeholding you lease, you know how long the duration is. Even a month-to-month rental, you know you're good for 30 days, but either one, you or the landlord can change your mind. So you have a beginning date, but no actual fixed termination date. Fee simple and life estate. There's two types of ownership interest for an indefinite period of time, an unknown duration. Fee simple is through inheritance, by deed, or will. Life estate is measured by a person's lifespan. Freehold estate. Fee simple is the most comprehensive. It's absolute and complete ownership. It can be inherited. It's also referred to as fee or fee simple absolute. The owner has the power to use, dispose, or descend to heirs. The other freehold estate is a life estate. Property is owned for the period of a lifetime. The owners or some other designated person. A conventional life estate is created by a person who holds title. When the life estate ends, the property is either an estate in reversion, where it goes back to the original grantor, or is given to remainderman, someone who the original grantor has named. Legal life estates are created by law. If a homestead is owned by one person and they die, their surviving spouse gets a life estate. When the legal life estate ends, the property goes to the surviving children in fee simple. Homestead. You have the right to homestead your principal permanent residence in Florida. There are protection and benefits. Protection of the family, like the legal life estate we just spoke of. Protection of the homestead from forced sales. What that means is, now if you don't pay your mortgage, your property taxes, your homeowners association, those things, they can foreclose on you and force you to sell your homestead. But, for example, if you have run up a hospital bill, credit cards, things such as that, boats, student loans, they can't force you to sell your homestead. That's what's protected. There are tax exemptions up to $50,000 from your assessed value. There are size restrictions of a protected homestead. It's 160 acres outside the city and a half acre within the city. And then there's some personal property protection of $1,000. Now, non-freehold. Non-freehold is your leasehold estates. They're measured in calendar time. It's a known duration. They're not freehold because it does not exist for an indefinite period of time. Non-freehold or less than freehold are other names. There's no ownership interest. All that's transferred is use and possession rights for a period of time. Leasehold estates. That's an estate for years, also known as a tenancy for years. It has a specific starting date and an ending date, designated period. We start this day, we end this day. It's created by written lease agreement and it establishes the tenant's interest in the property, but it does not convey legal title. Tenancy at will is a lease agreement with a beginning date, but no fixed termination date. It's considered a tenancy without specific term. And the notice to terminate is set in statute. Week to week is 7 days. Month to month is 15. not 30. Notice it's 15. Now, tenancy at sufferance, that's when a tenant stays in possession of a property beyond the ending date without the landlord's consent. It's considered a tenant holdover. If with written consent of the landlord, then it becomes a tenancy at will. Sole and concurrent ownership. Inseverability means that the property is held by one person, either sole ownership or severed ownership. Concurrent ownership means two or more persons own the property at the same time, and there are three types. There's tenancy in common, joint tenancy, and tenancy by the entireties. Tenancy in common, two or more people. They acquire title at the same time or different times, it doesn't matter. They have an undivided interest in the whole property, regardless of what their financial share is. Now, they can have equal or unequal shares of ownership, the financial part of it. And in tenancy in common, there is no right or survivorship. This is the only one that can be willed. Heirs inherit. Joint tenancy has a right of survivorship, which means the share of a co-owner that dies, their share is going to go to the surviving co-owner or owners, not to heirs. You cannot will joint tenancies. A joint tenancy has four unities. You remember it by the acronym PIT: possession, interest, time, and title. There has to be specific wording in the deed to provide for survivorship, such as joint tenancy with right of survivorship. Tenancy by the entireties, that's for husband and wife only, and they must be married to each other when they take title. It has the four unities of joint tenancy: PIT, possession, interest, time, and title. Actions affecting the property require the consent of both spouses, unlike joint tenancy. When one spouse dies, ownership interest transfers to the surviving spouse by right of survivorship. Cooperatives. That's a multifamily building owned by a corporation. Unit owners purchase shares of stock. Stock ownership entitles purchaser to a proprietary lease and the right to occupy. Property taxes are assessed on each unit. Owners can deduct real estate taxes and mortgage interest. And shareholders pay a pro rata share of the property taxes, and the corporation pays the tax bill. Cooperatives and cancellation disclosures. There must be a disclosure in the contract with the developer that states the buyer has a right to cancel within 15 calendar days of signing the contract and receipt of the cooperative documents. Disclosure in resale contracts has to state either the buyers received the documents 3 business days before signing, or the buyer has a right to cancel within 3 business days of signing the contract and receipt of the cooperative documents. Condominiums consist of condo units and common elements. A person owns a condo unit in fee simple plus an undivided fractional share of the common elements. A deed conveys ownership with a condominium. Unlike a cooperative, they get a proprietary lease, not a deed. With a condominium, the common elements are legally attached to each unit and transfers with the units. And unlike cooperatives, condominiums get their own individual tax bills. The condominium documents. A condo is created by recording a declaration of condominium. There are articles of incorporation, bylaws of the association, operational requirements, rules and regulations, FAQs, which provide information regarding leasing units and assessments, and an estimating operating budget. Developers. They have to file condo docs with the Division of Florida Condominiums, Timeshares, and Mobile Homes. 20 plus units must also file a prospectus. A copy of the prospectus and condo docs must be given to prospective purchasers. Purchasers have 15 calendar days to cancel the contract after signing the contract and receiving the condo docs. Resale purchase disclosures for condominiums. They'll get the declaration, articles of incorporation, bylaws, rules of the association, the FAQs, the most recent year-end financial information, and the governance form. They have a 3 business day right to cancel the contract after signing the contract and receiving the docs. Timeshares. Units are divided into time segments of ownership, usually 52 weeks. Deeds or other ownership evidence are prepared for each ownership segment. Statutory disclosure for timeshares are 10 days to cancel. License requirements. Real estate license is required to sell another's timeshare for compensation. There are exemptions. Salaried employees of timeshare developers selling timeshares for the developer, provided they're not paid a commission or on a transactional basis. Owners of timeshares can sell their timeshares themselves. The listing agreement required disclosure, talking about timeshare still. The commission requires written disclosure in listing, advertisements, and sales contracts that there's no guarantee of a timeshare sale. In addition, it is illegal to collect advance fees for a timeshare listing. The sales contract disclosures for timeshares must contain the current year's timeshare assessment. If property taxes not included in the assessment, the most recent property tax assessment. The form of timeshare ownership, the managing entity, the terms for closing and cost, and the existence of a mandatory exchange program. Timeshare ownership would be either in interval ownership or right to use. Interval ownership is fee simple ownership. Fractional interest is transferred by deed. Right to use, that's the usage of a timeshare being limited to a certain number of years. The ownership of the timeshare remains with the developer when that time is up.